Hello viewers, I am Dr. Shivani Gupta from the University Institute of Legal Studies, Punjab University, Chandigarh. It is my pleasure to welcome you to this session on an intriguing topic in the law of property, that is, transfer of property subject to encumbrances. This topic explores the enthralling interplay between immovable property and the encumbrances upon it. The purpose of this study is to make the viewers acquainted with the concept of encumbrances so as to make them aware of the intricacies involved while buying or selling an encumbered property. At the end of the topic, the viewers would be in a position to understand the basic concept of encumbrances, the types of encumbrances in the world of real estate, and the impact created by them on the transferability and title of the property. We shall be taking appropriate illustrations to make the understanding of types better. Also, we shall be discussing if property subject to encumbrances should be bought or not, and what are the legal implications involved in such transfers. So, first of all, let us know what is an encumbrance. A claim made by a third person against a property that does not belong to him is called an encumbrance. In terms of accounts, an encumbrance means constrained funds in an account that are specifically held in reserve for a definite purpose. Encumbrances in the real estate world usually refers to some type of a financial claim emerging out of financial difficulties, not always being compulsorily the case. Transfer of property subject to encumbrances means retailing a piece of immovable property while maintaining some existing liens or controls, for example, unpaid taxes, mortgages or legal limitations on the property. In such an arrangement, the purchaser attains the property under the burden of such encumbrances and becomes obligated to pay them off. These conditions are, however, clearly cited in the sale agreement and are ruled by the legal provisions applicable to the situation. In the case of National Textile Corporation versus State of Maharashtra 1977 judgment, it was held that an encumbrance is a charge or a burden created by transfer of an interest in a property. It is a liability attached to the property that runs with the land. Next is, what is the effect of encumbrance on immovable property? An encumbrance on an immovable property affects its transferability because many times encumbrances are such that they put limits and restrictions on the use of property till the time they are lifted. It limits the rights an owner or a buyer can have over the property, including the rights over the usage or alienation of the property. Thus, it is a right or an interest in favor of the third party, that is, neither the buyer nor the seller, that hinders or burdens the functionality or the transferability of the immovable property, thus also becoming less appealing to the prospective buyers. This makes it imperative to understand what are encumbrances in real estate and what is their impact on the property. They may even have the effect of dispossessing the property owner from his property or even seizure by the government agencies. Encumbrances like easements or liens can cause the title of the property being affected as unmarketable. Note here that the word unmarketable is not synonymous with the word unsaleable, but that it can enable the buyer to step out of the sale purchase transaction, even giving him the right to claim compensation in the appropriate cases. Other encumbrances like zoning impose some prohibitions on the use of encumbered lands. Now, let us study what are the various types of encumbrances that are possibly imposed on immovable property. Immovable properties may be subjected to various forms of encumbrances, which may affect the value and utility of an estate. Encumbrances may be attached to both personal property as well as real estate. Some encumbrances may be that harsh that they may have negative effects on the alienability of the property, while others may not be that restricting. They may be categorized as financial or non-financial, that is, legal encumbrances. Let us first study what are liens, that is, financial encumbrances. A lien may be understood as a type of monetary claim against an immovable estate affecting the title to a property. The purpose behind liens is to secure an obligation suffered by the actual property owner. It implies that if the imposed financial obligation is not met within the time stipulated, the lender will have all rights to seize and sell the property to make good for the amount lent. It thus suggests that before a property can be sold, it must be made free from all such liabilities, including any sort of payments to the creditor or the lender. Sometimes liens are even imposed by the persons who have worked on a piece of land for its betterment and under a stipulated contract, like hiring a contractor for making renovations to the house. The non-payment of dues by the owner to the contractor for the expenditures made and services provided in making the agreed renovations would give the contractor to file a lien on the owner. Here is an example to understand the concept. Let us say a contractor is hired by Mr. Singh to make some specific renovations to his house. He, however, fails to pay the dues to the contractor upon the completion of the job. The contractor now has the right to file a lien on Mr. Singh's house for the amount unpaid. Thus, such liens are financial encumbrances that represents the claims made by the claimants on another person's property, thus affecting the title of the property. It is when Mr. Singh pays back the dues, etc., that the property will become free from lien and the encumbrance. Similarly, it was also held in the case of Seth Ghasiram versus Achraj Kaur that maintenance charged on a property would be included to mean as an encumbrance. Another category of lien is a judgment lien. It is a legal claim granted to a creditor by the court through a judgment against the debtor's property. These claims are settled in lawsuits. For instance, Mr. Sham lent his friend Mr. Ram rupees 5 lakh, which he promised to pay back in 6 months. Besides being asked repeatedly to pay back, Mr. Ram did not pay. Now, when Mr. Shyam took a legal action against him, the court gave a judgment in favor of Mr. Shyam that Mr. Ram owes him rupees 5 lakh plus interest. Here, because Mr. Ram has no other source to pay off the amount decreed, a lien is thus created on his own flat, which now makes it difficult for him to sell that flat without paying off the debt. Further, if Mr. Ram continues not to pay the amount, Mr. Shyam can then force the sale of Mr. Ram's flat for recovering the money he is owed. Next category is a mortgage. Mortgage is also a type of lien on property. Mortgages are types of security interests, thus giving the lender, for example the bank, an interest in the title to the property till the time the total loan is paid off. Any default in payment by the borrower gives the lender the right to establish his claim over the property. This gives the lender the right to foreclose, to seize the property and even to execute eviction of the residents. Let us try to understand this with the help of an example. Mr. Singh purchased a flat in Chandigarh by taking some loan from a bank X. He keeps the same flat as a collateral, that is security. Thus, we can say that the bank holds his flat as a mortgage. Now, this flat has got an encumbrance attached to its title, which can only be cleared once Mr. Singh pays off the whole of the loan amount. Thus, this has resulted into a financial claim on the flat by the bank, which can only be foreclosed by the bank only after Mr. Singh pays back the whole loan in full. Next category is non-financial encumbrances. One of its type is easements. An easementary right is a claim that restricts the use of a certain land for the beneficial use of an adjacent land. It is a claim by a piece of land that dominates over the other adjacent land known as the servient heritage. It restricts the rights of the owner of the servient heritage for the beneficial enjoyment of the owner of the dominant heritage. Easements can either be affirmative or negative in nature. An affirmative easement allows the easement holder to use a property as defined by the easement. For example, the workmen of a factory A uses a passage on the land of the adjoining factory B as their right of way. This passage represents an easement on the owner of factory B, allowing the workers of factory A the right of way. Though it is not a financial encumbrance, it however restricts the owner of factory B full use of his property, as he cannot obstruct this passage, which must remain open and accessible to the workers of factory A. On the other hand, the holder of a negative easement has the authority to stop another party from performing certain functions, like not opening a window in the wall connected to their courtyard. Easements are thus non-financial encumbrances. There is another category which is also an easement. It is called as an easement in gross. It is an easement not connected with the land for its beneficial use, but an easement for the benefit of the owner as an individual. These easements thus get invalidated once the individual owning the easement moves. Such easements, since they do not pass automatically with the transfer of the property, they are not those type of encumbrances that would affect the marketability of the surveyant heritage. Next kind of an encumbrance is a lease, often understood as renting a property. It is an agreement under which one party rents out a property to another party, either individual or artificial person, for a priorly agreed terms and conditions, especially pertaining to the time period, the rent, and the conditions that forbid the use of the property for certain practices. In case of leases, the encumbrances attached with the property is such that though the landlord does not give up his title in the property under lease, but still it does result in him having very limited rights in the property, especially pertaining to the use of property by him. Leases often contain a guarantee that the lessee's right to possession and to enjoy the property won't be affected by the transfer, that is the sale of property, for the already agreed upon duration of the lease. Also, that the lessee would have the right to continue in possession and enjoyment of the land upon the same terms and conditions as had been entered into at the time of the lease. For instance, Mrs. Seth owns a triple-story building and agrees to lease a floor of it to a garment factory for 10 years. This agreement is an encumbrance that grants the garment factory the right to occupy and use the leased space, and at the same time affects Mrs. Seth's capacity to sell or alter the part of property under lease without considering the terms of the agreement. The next type of encumbrance is a restrictive covenant. A seller of real estate may include a clause in the deed of transfer that restricts the usage of the property being transferred to the buyer. Such clauses may be understood as restrictive covenants. Let us understand this with the help of an illustration. Mr. Mahajan rents a flat in a high-rise building at the 11th floor. The Residents Association of the building has set a rule that the flats in the building shall only be used for residential purposes. There is a restriction against the flats being used for commercial purposes. This condition is a kind of a restrictive covenant that prevents Mr. Mahajan from using his flat to run a business. Further, the covenant is a non-financial encumbrance, but restricts how Mr. Mahajan can use his flat for ensuring the residential nature of the building. It is important to note here that for the imposition of such restrictions, it is not necessary that they must have been practiced there as a matter of custom since some time. However, such restrictions may even be imposed on new constructions so as to make all the residents of the building or the society liable to follow certain rules, standards, specifications, etc. Unless a restrictive covenant is against the tenets of the law in force, they can be as arbitrary, as weird, or as vague as the parties involved are willing to agree to. For instance, one may require the buyer to always maintain the original facade of the building intact, despite the fact that it may have a weird shape and look, but the parties to the transaction are agreeing. The covenant applies. Theoretically, restrictive covenants are not encumbrances in the real sense, though it may impose some restrictions. Another aspect, encroachment. Any physical intrusion or interference in a property by someone who does not own that property is termed as an encroachment. They have the tendency to give rise to legal disputes. Even planting of trees at just the boundary such that its branches hang over the adjoining property amounts to an encroachment. Encroachments do not lead to any direct encumbrances, but they do result in the creation of some encumbrances upon both the properties in question till the time the issue gets resolved. Again here, this is something called as zoning. Sometimes encumbrances may even be applied by the enforcement of municipal or state laws, either in the form of environmental bars, environmental regulations, or zoning laws. These are basically encumbrances by government. Thus, they are type of legal encumbrances. Such laws may often impose limitations on making certain types of constructions, either changes or new on a property, or may even impose limitations on the use of some property for certain purposes. A very simple instance to understand this is that the municipal laws applicable in the city Chandigarh restrict the use of residential houses for carrying out businesses or commercial activities. Similarly, commercial properties cannot be utilized as residences unless they are specifically demarcated as SCFs, that is shop cum flats. Restrictions that impose limits on the type of septic units being used if it does not comply with the environmental regulations also amount as encumbrances. Next is, what are the legal aspects, what are the legal provisions concerning encumbrances? Under the Transfer of Property Act 1882, the provisions contained under section 55 summarizes the rights and liabilities of the parties involved in such transactions. This section obligates the seller to disclose all the existing encumbrances on the property proposed to be sold. Section 55(1)(g) says that the seller is bound to pay the interest on all encumbrances on such property due on such date, and except where the property is sold subject to encumbrances, to discharge all encumbrances on the property then existing. Further, section 55(5)(b) states that where the property is sold free from encumbrances, the buyer may retain out of the purchase money the amount of any encumbrances on the property existing, and shall pay the amount so retained to the persons entitled thereto. And under section 55(5)(d) that the buyer is bound, where the ownership of the property has passed to the buyer, to pay the principal monies due on any encumbrances subject to which the property is sold and the interest thereon afterwards accruing due. All this implies that it must be the topmost priority of the seller to clear all encumbrances on his property before selling it. In the case of Bhagwati versus Banarsidas 1928 judgment, it was held that where the vendee had to make a payment to the mortgagee in discharge of an undisclosed encumbrance, he was entitled to reimbursement under section 69 of the Indian Contract Act, as the vendor was obligated under section 55(1)(a) of the Transfer of Property Act to discharge all the encumbrances. In case the seller had made all declarations and promises declaring the property as free from any encumbrance, still if the buyer finds out about the existence of any encumbrance on such property, he may either hold a part of the acquisition cost to clear that encumbrance or even choose to annul the contract and file a suit for damages. If, however, the transfer of property has taken effect along with the encumbrances, it is the buyer of the encumbered property who becomes subject to the payment of any such dues or interests either existing or those that might accrue subsequently. In the case of Palla Malai Mudaliar versus the South Indian Export Company, it was found that only a portion of the consideration was paid and that went towards the discharge of an encumbrance on the property. In that case, the learned judges held that the transaction was void as it was intended to defeat or delay creditors, and that inasmuch as the transferee had discharged a valid mortgage on the property, it would be equitable to give him a charge for the amount which he expended in discharging the mortgage decree against the suit property. Section 57 of the Act, however, is another provision relevant to encumbrances. Though it is a least used provision, however, it provides that an encumbered property may be declared free from encumbrance if the property is the subject matter of a sale. Under this section, the court has the authority to declare a property free of encumbrance even if the declaration sought is against the will of the encumbrancer. Now, the next question is, why is it important for us to know about an encumbrance, especially while buying some property? And also, whether buying an encumbered property would lead us into some sort of damage or not. Before making a decision or an offer for purchasing a property, it is eminently necessary for any prospective buyer to find out if the property is subjected to any sort of encumbrance. This can be done by performing a little title search or search by the property number as entered in the municipal records, by logging onto the relevant public domain. Many times, even real estate lawyers may help you find out the true status of such property, especially if we approach them via some banks for securing loans for the purchase of that particular property. Generally, encumbrances like zoning or leases are less bothersome as compared to mortgages or property tax liens. Thus, it may be concluded that a claim made by a third party against a property is an encumbrance. Such a claim is made by someone but not the current title holder. Such claims include leases, mortgages, easements, property taxes, etc., which do affect the value of the property. There are many encumbrances that transfer automatically with the transfer of title in the property. Wherefore, it becomes necessary for any prospective real estate buyers to be cautious enough to find out if there is any encumbrance, any of its type attached to the property wish to be purchased. Encumbrances may be time consuming, infuriating and even costly to deal with. This was all about transfer of property subject to encumbrances. See you in the next lecture. Till then, thank you and goodbye.